Someone right now is sitting at a kitchen table, holding a legal document they think protects everything they have. Their house, their savings, their retirement account, their life's work. And in that same document, buried in language most people would need a law degree to understand, is a clause that could hand every single one of those things to someone else, legally, permanently, with almost no way to stop it. We are talking about a power of attorney, and if you or someone you love has one, or is about to sign one, what you are about to hear could be the most important financial information you will receive this year. Because here is what nobody tells you at the attorney's office. A badly written or badly managed power of attorney is not just ineffective. It is a loaded weapon pointed directly at your bank account. I am going to walk you through 7 of the most devastating mistakes people make with these documents. Some of them happen before the ink is even dry. Others happen years later, when it is far too late. And by the end of this video, you will know exactly what to look for, what to demand, and what questions to ask before you ever let anyone manage your money on your behalf. Stay until mistake number 4. That is the one attorneys almost never warn their clients about, and it has cost families hundreds of thousands of dollars. Mistake number 1. Signing a springing POA without understanding when it activates. Let's start with a mistake that trips up even the most careful planners. You sit down with an estate attorney. You sign a power of attorney. You feel responsible and prepared. What you might not realize is that you just signed a document that is completely useless right now. There are 2 types of power of attorney. An immediate POA activates the moment you sign it. A springing POA only activates when a specific condition is met. Usually that condition is incapacity, meaning the document does not kick in until a doctor certifies that you can no longer manage your own affairs. That sounds reasonable, even thoughtful. But here is what happens in real life. You have a stroke. You are in the hospital. Your agent, the person you trusted, goes to your bank to access your funds for your care. And the bank says, "Sorry, we need proof of incapacity from a licensed physician." Your regular doctor is on vacation. The hospital paperwork is delayed. The billing department needs payment now. And your money, which was supposed to be accessible, is locked behind a bureaucratic wall at the worst possible moment. This exact scenario played out for a family in Ohio. Their father had a massive cardiac event and was hospitalized. The son held a springing POA, but getting the required physician certification took 11 days. During that time, automatic payments lapsed, an investment account flagged the inactivity, and a scheduled wire transfer was canceled. The family lost access to over $40,000 in liquid funds for nearly 2 weeks during a medical emergency. We thought we had everything in order. We had no idea it would not work when we needed it most. The fix is not complicated. You need to ask your attorney, is this immediate or springing? If it is springing, what exactly triggers it? How many doctors need to certify incapacity? And what institution specifically will accept that certification? Get those answers in writing before you sign anything. Mistake number 2. Naming only one agent with no successor. Here is a question most people never think to ask. What happens if the person you named as your agent cannot serve? They get sick. They die. They move across the country. They get divorced from a family member and the relationship implodes. They develop their own cognitive decline. Any of these things happen, and your power of attorney becomes worthless because it names exactly one person, and that person is gone. This is not a rare edge case. A national survey of estate planning attorneys found that in nearly 1 in 3 cases where a POA failed to function as intended, the reason was either the death of the named agent or a relationship breakdown that made the agent unwilling or unable to serve. A woman in Florida named her older sister as her sole agent. Her sister passed away suddenly at 68. By the time the woman realized the document was void, she was already showing early signs of dementia and no longer had the legal capacity to execute a new power of attorney. Her family had to go to court to establish a guardianship. The legal fees exceeded $22,000. The process took 9 months. And here is the kicker. Her sister had been dead for 2 years before anyone caught the problem. She always said she had her affairs in order. Technically, she did, until she didn't. The solution is simple. Name at least one successor agent. Some people name 2. Your document should clearly state the order of succession and what conditions trigger a transition from primary to secondary agent. And then you need to review that document anytime something changes in your life or in the life of your named agent. Mistake number 3. Using a generic online template instead of state-specific language. You have seen the ads. $5. Download your power of attorney right now. Complete legal protection in 10 minutes. Thousands of people click that button every single day. And every single day, some of those documents end up being completely rejected by the institutions they were meant to work with. Here is what those template sellers do not tell you. Power of attorney law is almost entirely governed at the state level. What is legally valid in Texas may be rejected in New York. What a bank in California is required to honor may not be recognized by a financial institution in Georgia. Some states have very specific language that must appear in the document. Some require specific font sizes. Some require that certain warnings be printed verbatim or the document is void on its face. The American Bar Association has documented cases in nearly every state where a validly executed POA from one state was refused by an institution in another. If your agent ever needs to act across state lines, which happens far more often than people expect, a generic template is not just inadequate. It is a liability. A retired couple in Illinois used a nationally distributed template they found through a financial planning website. When the husband suffered a debilitating injury and the wife needed to access a brokerage account in his name, the brokerage firm's legal department rejected the POA. Their reason? The document lacked the specific statutory language required by the state where the account was held. The couple had to hire an attorney, wait for new documentation, and lost access to $68,000 in a market account during a period of significant volatility. They had done their homework. They had thought they were protected. The template had failed them completely. If you insist on a low-cost solution, at minimum, use a state-specific form from your state's bar association or court system. Better yet, spend the $200 to $400 to have an actual attorney draft it correctly. That is cheap insurance against a very expensive mistake. Mistake number 4, granting unlimited financial powers without any guardrails. This is the one. This is the mistake attorneys do not warn you about loudly enough, and it has quietly devastated more families than almost any other estate planning error. A general financial power of attorney, the most common type, can grant your agent the power to do almost anything with your money. Open accounts, close accounts, transfer funds, make investments, take out loans, gift your money to other people. In some cases, even change the beneficiaries on your accounts. Read that list again slowly. Most people sign a broad POA imagining a specific, limited scenario. They imagine their agent helping pay bills during a hospital stay. What they have actually signed is something far more expansive. And when the person you name turns out to be less trustworthy than you believed, the consequences can be catastrophic. Financial elder abuse by an agent acting under a power of attorney is one of the most underreported crimes in the United States. The National Council on Aging estimates that financial exploitation affects 1 in 10 Americans over the age of 60. And unlike fraud by a stranger, abuse by a named agent is staggeringly difficult to prosecute because the agent was legally authorized to act. A man in Arizona named his adult son as his agent under a general POA after a hip replacement surgery. Over the following 14 months, the son transferred over $230,000 from his father's accounts. He paid off his own mortgage. He funded a business venture. He made gifts to his own children. All of it perfectly legal under the document his father had signed. The father did not find out until he tried to sell his home and discovered his financial accounts were nearly empty. I trusted him completely. That document gave him everything he needed to take advantage of that trust. You can protect yourself. A well-drafted POA includes specific limitations on what the agent can and cannot do. You can prohibit gifts above a certain amount. You can require co-signatures for transactions above a threshold. You can exclude specific accounts entirely. You can require the agent to provide accountings to a third party. These are not complicated provisions. A competent attorney can include them in an afternoon. The question is whether anyone told you they existed. Mistake number 5. Never reviewing or updating the document. When was the last time you looked at your power of attorney? If you have one, pull it out right now and look at the date. If it was signed more than 5 years ago, you may have a problem. If you signed it before any of the following life events, you almost certainly have a problem. A divorce or remarriage, the death of your named agent, a move to a different state, a significant change in your financial situation, a falling out with a family member, the birth of grandchildren who might now be better suited as your agent than the person you originally named. Some financial institutions have started refusing to honor powers of attorney that are more than a certain number of years old, regardless of whether the document itself has an expiration date. J.P. Morgan Chase, Bank of America, and Wells Fargo have all faced legal disputes over their refusal to honor what they considered outdated POAs. Whether they were right or wrong legally, your agent still had to fight them in court to access your funds. In one documented case, a woman in New Jersey had executed a POA in 2009, naming her then-husband as her agent. The couple divorced in 2012. She never updated the document. When she was hospitalized in 2021 with a serious illness, she was cognitively impaired and unable to update it. Her ex-husband, still legally named as her agent, had full access to her accounts. The courts ultimately intervened, but not before the situation created a legal battle that consumed 18 months and most of the family's goodwill. The rule of thumb from elder law attorneys is simple. Review your POA every 3 to 5 years and immediately following any major life change. Set a calendar reminder. Treat it like a smoke detector battery. You do not wait until it fails to replace it. Mistake number 6. Not registering or communicating the document to financial institutions in advance. Here is a scenario that plays out in bank branches across the country every single week. A person walks in with a valid, properly executed power of attorney. The bank's compliance department has never seen this document before. They send it to their legal team for review. That review takes anywhere from 48 hours to 3 weeks. Meanwhile, your agent cannot access a single dollar. Most people treat a power of attorney like a fire extinguisher. You put it in a drawer and you expect it to work when you need it. What they do not realize is that financial institutions have their own internal processes for verifying and honoring these documents. And if your institution has never seen your document before a crisis hits, you are starting a bureaucratic process at the worst possible time. Many major banks, brokerage firms, and investment platforms now allow account holders to pre-register a power of attorney on file. Some actually require it. Fidelity, Vanguard, and Charles Schwab all have formal processes for accepting and notating POAs in advance. Some institutions will only honor their own proprietary POA form, meaning the document your attorney drafted may be rejected, regardless of how perfectly it was executed. A family in Michigan discovered this the hard way when their mother was incapacitated following a stroke. The agent, her daughter, had a perfectly valid Michigan statutory POA, but the brokerage firm holding her mother's IRA only accepted their own form. The daughter spent 6 days on the phone, faxing documents, escalating to supervisors, while a required minimum distribution deadline loomed. The account was eventually accessed, but not before the family incurred a tax penalty they are still disputing. Call every financial institution where your accounts are held. Ask them, do you have a preferred POA form? Do you accept third-party POAs? What is your review process? Can I pre-register this document now? A few phone calls today could save your family a month of anguish later. Mistake number 7, choosing the wrong person for the wrong reasons. We have saved this one for last, not because it is the most technical, but because it is the most human and the most painful. Most people choose their power of attorney agent the same way they choose who sits at the head of the Thanksgiving table. They choose the person who feels right, the oldest child, the most financially successful sibling, the one who lives closest, the one who has always seemed the most responsible, the one you do not want to offend by leaving out. None of those are good reasons, and every one of them has led families into disaster. Being your agent under a power of attorney is one of the most demanding, thankless, and legally perilous roles a person can take on. It requires meticulous record-keeping. It requires the ability to make complex financial decisions under emotional duress. It requires the willingness to say no to family members, to institutions, even to the principal themselves. It requires total availability during a crisis. And it requires the integrity to handle someone else's money without ever, even once, letting self-interest creep in. Do you know anyone who ticks every one of those boxes? Because the right person is not necessarily the family member you trust the most emotionally. It is the person best equipped to handle the job professionally. An elder law attorney in Texas told me this about agents. I have seen more families destroyed by who they chose than by anything they put in the document. The document is just paper. The agent is the whole ball game. A California family named their youngest daughter as agent, not because she was the most financially sophisticated, but because she was the most available and the easiest to get along with. When her mother entered memory care, the daughter became overwhelmed managing the accounts, the property, the insurance, the government benefits. She made errors. She missed deadlines. She was not malicious. She was simply in over her head. The resulting financial mismanagement cost the estate over $90,000 in avoidable fees, penalties, and missed benefits. Consider a professional fiduciary if no family member is truly equipped for the role. A licensed professional fiduciary is trained, bonded, and legally accountable. Yes, they charge fees, but those fees are almost always far less than the cost of a family member making well-intentioned mistakes with a six-figure estate. And if you do choose a family member, give them the tools to succeed. Walk them through your accounts. Introduce them to your financial advisor. Create a written document that explains what you own, where it is, and what your wishes are. Do not just hand them a legal document and assume they know what to do with it. Closing. What you should do right now. Let me bring this home because the goal here is not to scare you. The goal is to make sure you actually have the protection you think you have. Here is what I want you to do before you close this video. First, find your power of attorney if you have one. Look at the date. Look at who is named. Ask yourself honestly whether that person is still the right choice, whether the document still reflects your actual life, and whether anything has changed since you signed it. Second, if you do not have one, do not go to a download site. Call an attorney who specializes in estate planning or elder law. Most offer flat fee packages for basic documents. The cost of getting this right is a fraction of the cost of getting it wrong. Third, call the financial institutions that hold your accounts and ask specifically about their POA policies. Get the answers in writing if you can. This single phone call has saved families from nightmares that lasted years. Fourth, have a real conversation with the person you plan to name. Not just, hey, I am naming you in my will, but a real, detailed conversation about your finances, your wishes, your accounts, and your expectations. If that conversation feels awkward, imagine how it feels during a medical emergency when no one knows what to do. And fifth, review it. Put a date in your calendar. Set a reminder. Treat this document the way you treat your health. You do not see a doctor once and assume you are covered forever. The same logic applies here. The law does not protect people who have the right intentions. It protects people who have the right documents. And the right documents are only as strong as the people who drafted them, signed them, and updated them when life changed. Power of attorney is one of the most powerful legal instruments an ordinary person can hold. Powerful enough to protect everything you have built, and powerful enough in the wrong hands or in the wrong form to take it all away. Do not let that happen to you. Do not let that happen to your family. If this gave you something to think about, share it with someone who needs to hear it. A parent, a sibling, a friend who keeps saying they will get to the estate planning eventually. Eventually has a way of arriving when it is already too late. Hit subscribe if you want to keep pulling back the curtain on the financial, legal, and consumer decisions that most people do not understand until it is too late. Because the truth is not always on the menu, but we will always put it on the table.